So, assuming you can't find a solution, you have to, as the lawyer, prepare the papers for the court case, and this is the demanda.
Demanda,
Yes.
correct.
And that sets out the story and what you want the court to do.
Yeah.
How long does that take to file the demanda?
It depends. It depends because in Spain we have some types of codes, okay, depending of the subject. Okay, we have civil codes, we have social codes, okay, administrative codes, and criminal codes. It is that depending of the subject of the dispute.
Yes.
Depending of the subject, if we have a problem with the company that is not paying you and the salary is unpaid in the last 6 months, we must go to the social code. Okay, we cannot go to the civil code to solve that dispute. Depending of the subject, we must go to that specific code, and the procedure is different.
Now, just pausing there for a moment, we do have a separate guide about the legal system in Spain and which types of cases go to which courts. So if that's of interest to you, there will be a link to it on the information box in this video. For the rest of this video, let's focus on cases that go to the civil courts, because that's the large majority of the sorts of conflicts in which clients tend to become involved, I guess.
Okay.
So you file a demanda, and then what happens? Which court does it go to?
It goes to the court where you have the problem. Okay.
So if it's a problem in Marbella, it would go to the court in Marbella.
That is.
Yeah.
It is that. First of all, it is necessary to analyze the jurisdiction, okay, of the court. If the problem is about a property in Marbella, it must go to Marbella. If the problem is with somebody who owes some money to you and that person is living in Malaga, it must go to the court in Malaga.
Yes.
Okay?
So it goes to the court where the person you're claiming against lives.
That is.
Yes.
That is. And when we prepare the demand, in that demand must be an explanation of all facts.
Yeah.
Okay? What has happened, what is our position, okay? And it is necessary to do mention about all evidence that we have to defend our position. Okay? It can be a document, it can be an email, or it can be some witnesses that we are proposing in that demand that we want to use during the court case.
Yes.
It is that in the demand, it is very important that we do mention of all evidence that we have in our file. Okay?
And so really, when the judge receives these papers from the court, he should have a pretty clear idea of what this case is all about.
That is.
Yes.
It is that is going to have a clear vision about what that part is claiming. And the judge, the court, is going to do a preliminary study of that demand in order to confirm that from the formal point of view, everything is correct.
So if you've not supplied one of the pieces of paper that are required, they'll reject the case and say, come back again.
That is.
Yes.
Or if I am submitting the demand in the court of Barcelona, when
yes.
it should be in Malaga,
Yes.
then the court is going to refuse that demand,
Yes.
and will let you know, okay, you must go to the proper court to deal with this.
So assuming the court accepts jurisdiction for the demand,
Yep.
what then happens?
In that case, the court is going to communicate that demand to the other part. Okay.
This is by post?
It is by post through a specific procedure through the court. Okay. It is that the court is going to appoint one specific person from the post office in order to communicate that demand, or the post office will send you a letter informing you that you must go to the court to pick up the demand.
Right.
It is that the demand, it normally is a big document.
Yes.
Okay, it's a big document with 20, 30, 50 pages. Okay, it is that in some cases the usual way is that you are receiving a letter informing you you must go to the court to this address because a demand is waiting for you.
Okay. And so, assuming you go to the court and pick up the demander, what
Yeah.
happens next?
You have 20 days the normal civil case, you have 20 days to respond the demand. That is important.
Very important.
That is important because it's a short time, the time that you have.
Especially if you live in New York and the case is in Barcelona.
That is.
Yes.
That is very important because in 20 days, the reply to the demand must be submitted on court.
Otherwise, you lose the case.
You lose the case.
Yes.
It is that is the time that you have to appoint one lawyer to study the case, to prepare the defending of your position, to analyze the evidence that can be used, to analyze the evidence that the other part has used, and 20 days is a short time to do that.
And of course, if it's a very complicated case, the lawyer can go to the court and say, I need a bit more time, but they can file a preliminary reply to the case.
That is.
Yes.
It can happen, but in Spain, that is only going to happen if it is a very complicated
Exactly.
case.
In most cases, you have to comply with the 20-day.
20 days.
Yes.
In 20 days, you must do everything.
Now, of course, one of the things, it seems to me, that flows out of that is that if you know you're in a dispute and it's likely to go to court, it's a good idea to see your lawyer early, before you receive the demander, because that will give your lawyer more time to prepare.
That is. It
Yes.
is that, and that is advisable to have your lawyer informed about what is going to happen. Okay?
Yes.
And then the lawyer can start preparing the demand, can start working in the case.
Yes.
If you are receiving a demand and you haven't appointed one lawyer, if you haven't a lawyer, first thing that you must do is to contact with a lawyer on the first day.
Yes.
Don't waste time, 5 days, 10 days, talking with...
If only it was 5 or 10 days.
Yeah.
Sometimes the people come on you on the 18th day.
It happens.
Yes.
It happens.
Yes.
It happens because you have been talking about the demand with the other part. You have called a friend. You have done, and then at the end of the day, you are wasting the time that we have to prepare the demands to defend your position. First thing, if you are receiving a demand, contact with the lawyer immediately.
Okay. Now let's just go back a little bit. What happens if you get the letter from the post office saying go to the court and pick up the papers and you just ignore it?
It is that if the court case is going to notify you in 2 occasions, okay, and you ignore 2 times the letter that you are receiving from the court procedure is going to continue without you.
Right. Okay. So the 20 days would start to run and you would lose the case.
You will lose the case because, at the end of the day, it's a decision of the judge.
Of course.
Okay, it is that in the demand you must have enough arguments to win the case. Okay, but 99% that you will lose the case.
Yeah. If you lose the case when the other person isn't contesting it, there must be something really wrong with the demander.
Yeah.
But basically, therefore, if you don't reply, you get 2 opportunities to pick up the papers, and if you don't do it, then you will
the
lose
procedure
the case.
will continue without you.
Yes.
Okay.
Now, of course, this gives rise to a practical problem, doesn't it? Because if I am a foreigner and I have a dispute, say, with the builder who installed my swimming pool, the builder will issue the demander, and the address for you in that demander is likely to be your home here in Spain, not your home in Chicago.
Yeah.
And so the court sends the paperwork to your home in Spain. You're not there. You may not be back for 6 months.
Yeah.
And then they send a second letter and you're not there.
Yeah.
And now you're in trouble.
Yeah.
So how do you deal with that?
It is that when the procedure is going to continue without you, is when you are receiving the notification from the court and you are ignoring it.
Right. So it's like a registered letter you get where you have
letter is that the post office has the confirmation that you have received the letter and you haven't gone to the court for the demand. It is that is only when the procedure is going to continue without you, when you have had the opportunity to be in the case and you have ignored the court case, but you knew about that.
Yes.
Okay.
And of course, very often at this point anyway, your lawyer would be already in contact with the other person's lawyer, so this question of addresses should be sorted out.
That is.
Yes.
That is. If you are not living in Spain, okay, it is that, and that notification is going to be done about the starting of case, the demand, then the court is not going to start the procedure until they have the confirmation that you have been notified.
And that might be being served with the paperwork, notified with the paperwork in the country where you live.
That is.
And there's a special process for that.
Except in some specific process when the law considered that you had the knowledge about that procedure was going to happen.
Yes. Okay, so you have filed your demanda, the person has 20 days to reply, their lawyer has now filed an answer to that demanda, setting out the defence, saying we do not accept this and this and this, and we say that these are the facts, not those are the facts, and so on.
Yeah.
And what's the next step?
Next step is that both parties will wait for the preliminary hearing.
So the case will be allocated to a judge, and there will be a hearing fixed.
Yeah, that will be a hearing between both parties that is going to be done by the lawyers. Okay, no, the clients are not going to be there. And in that hearing, what is going to happen? That is a meeting, okay, on the court between the judge and the two parties, the two legal representatives of each part, in order to, first of all, to see if there is any possible agreement between both parties, because it can happen that during that procedure we have got an agreement, and that will be the act in which we must state what is the agreement that we have got.
Yes.
And if there is no agreement, we will prepare the trail.
Yes.
Okay? It is that we must inform to the judge about the evidence that we are going to use in the court case, and the judge will approve that. Okay? It can happen that if we want to use 10 witnesses in a case, the judge is only going to approve only 3-4 of them.
Yes.
Okay? It is that we will confirm in that hearing what is going to happen and what is going to be done on the trail.
And if you were starting a court case here in Marbella, roughly how long is it between starting the court case and the day of the preliminary hearing?
A long time. It can take. It depends of the court, because for example, in Marbella we have some number of courts. Depend how busy is the court at this moment. But to give you an idea, a court case can take more than between 12-14 months.
Yes, to get just to the preliminary hearing.
To the hearing, it can be 6 months.
6 months to the preliminary hearing.
Okay.
And it's fair to say, I think, that in other places in Spain where there are very few judges and very many court cases, it can take a very long time to get to these things.
A very long time. It is that here in the Costa del Sol, for example, is not all this. We have different courts.
Yes.
Okay? We have in Marbella, we have in Estepona, we have in Fuengirola, for example. The same case in Estepona can take. The hearing will take more than a year.
Yes.
Okay. In Marbella, maybe it's 6 months. It depends how busy is the court that is at that moment and how many courts we have in that city.
Yes.
Yeah.
And of course, what people may say, well, why does it take that long? Well, one of the problems you've had in Spain is the tourist industry, because the number of judges in a particular area is allocated by the government, and it might have been allocated 20 years ago when there were only 15 men and a dog living here, and now there are 200,000 foreigners who own houses here, and those foreigners are still using the services of only the same 2 judges, so it can be a problem. Yeah,
it can be a problem, and it happened that during the summertime, courts are very, very busy, and maybe it's the same court who must deal with the investigation of some criminal cases than with civil cases. And they give the priority to some things to others. Yeah.
So when you go to your preliminary hearing, does the judge basically beat you up to try and get you to come to a settlement?
The judge will ask the lawyer about that.
Yes.
If it is possible to get an agreement.
Yes.
But the judge is not going to force you or is going to push you in order to get an agreement. It depends of the circumstances, depends of the cases that can be done or not. Normally, when we get an agreement in the hearing, it is because we have been negotiating about that during the previous weeks, months.
Yes.
Okay? Is something that is not going to happen suddenly at that day. Okay.
And so if there isn't a possibility of a settlement, then the judge will make orders and he will say you can have 6 witnesses or whatever. And his duty here is to ensure justice. Is that his primary objective, deciding which witnesses can be called and which can't?
That is what will be done.
And you then, if you can't get a settlement rather, you prepare for trial.
We prepare for trial.
And what sort of things, and don't want to go into all the detail, but what sort of things is the lawyer going to be doing when he's preparing for trial?
For preparing the trial, first thing it is necessary to prepare the main content of the demand. Okay. Obviously, in the trial, it's not necessary to go again through all that is in writing because the judge has that in writing. Okay. But you must go through the main points of the demand. And it is very important to go through all the evidence that you are using in your file. During the trial is when all evidence are going to be studied.
So, for example, there might be 4 witnesses.
Yeah, it is that 4 witnesses are going to be there. One of the lawyer will do question. The lawyer of the other part has the right to do question to that witness, and that is during the trial when we are going to use that evidence, what that witness has said, in order to defend our position. It is that we must do a link between our arguments and all the evidence that we are doing during the trial.
Yes.
Okay?
And so eventually you get to the date of the trial, and again in Marbella, how long would it take normally to get from the preliminary hearing to the time when you had the trial?
It is that from the moment of the demand to the hearing, it can be 6 months. Okay?
Yes.
And for the trial, it can be 12 months, 14 months for that from the demand.
Yes. Okay, so you get to the trial and the judge will make his mind up. Either you will win or you will lose.
Yeah.
If you win the court case, what happens next?